Go back to the House Environment Committee. We are going to shift gears and walk through with our legislative council, the Senate chloride bill, which is this one, 218. Welcome, Michael.
Good afternoon. This is Mike O'Grady with Legislative Council. Before I walk through the bill, I want to give you some context for what the bill is about and potentially who you should talk to about that. I think you have all heard of the term a TMDL, how the state is required to go out every 3 years and assess the waters of the state, determine if the waters are meeting the water quality standards. If they're not, identify what's causing any impairment and to come up with a plan to fix. So over the past few years, the agency's been going out and chloride levels and waters is increasing, I would say, across all regions of the state, more so in more developed regions like Chittenden and Franklin County. And there are lakes, there are water segments that have been identified as impaired for fluoride. This document has, there should be 8, but there's only 7 on here. No, there's 8, I'm sorry, I just can't count. And so what do you do when you have a TMDL? You come up with a plan for how you're gonna bring that water back into compliance with the water quality standards. Well, the biggest source of chloride in state waters is road salt from application by state, municipal, and local, state, municipal, and others, private, and then also just people putting salt on their driveways. So the purpose of S218 is to create a program, a voluntary program, that commercial salt applicators can choose to participate in which they are trained on best management practices for application of salt and salt alternatives. Once they complete the program, they are designated a certified commercial salt applicator. And if there are any damages that occur from their application of salt or salt alternatives, they get an affirmative defense that they are not liable. And that affirmative defense also applies to the property owners where they are applying salt or salt alternatives. Now, there are a couple of variations. AOT is exempt because AOT already has its own practices. Municipalities aren't part of the commercial salt applicator program. They're going to be part of a local roads program, but they still receive similar benefit. And there's a report in the bill about the covering of salt sheds, salt storage. It is not a mandate. It is not a requirement that municipalities cover salt or move their salt piles. It's just effectively an inventory. What needs to be covered, what needs to be moved, and what it would cost to do that. There's no mandate on municipality.
This is a bill that we worked a lot on last year. And I guess sounds pretty similar so far.
It's very similar. I think the variation was the affirmative defense was sort of insisted upon in the Senate. Where in the House, it initially was just effectively immunity from liability. That, and I can explain the difference when we get to the affirmative defense. So with that said, I'm just going to walk through the bill as passed by the Senate. I don't know if that's on your website because I don't.
It is.
I haven't had time.
I have a question though. chloride TMDLs, is that up from last year, or is that the same number as last year?
It's up from last year, and they haven't actually come up with the TMDLs for all of them. These are the ones that need them. And I think there are 3 that have actually been developed. And so they're all in Chittenden, Shelburne, South Burlington, Burlington, Colchester, Winooski, Williston. But when you look at the map of where the chloride is spiking, you'll see that it's not just Chittenden County. It extends up into Franklin. St. Albans looks like it's an issue. Looks like it's an issue probably in Montpelier. Starting to be an issue in Rutland, not as big of an issue. But it's not just Chittenden County.
Representative North.
Just a question on what sort of waterways that are impaired, or you were kind of listening by county? Usually it's not by county, usually it's kind of like watershed and waterways.
So when they go out to identify impairments, they go by segment of the water. And so it could be a segment of a lake, it could be a segment of a stream, river. Because they have to look at each segment to determine whether or not the traditional uses of the water are being met, being achieved.
I expected it to, rather than just county, but you were just saying that.
That's
segments have to
just-
be- have to
right.
be in those counties.
Those segments are in those counties. All right, so the bill has passed the Senate. The section 1 is just a purpose section setting forth that the purpose to is establish accepted standards of care for application of salt in a way that provides safe conditions while also reducing the impacts of salt alternatives and water quality. Page 1, line 10, this creates a new subchapter in the water quality chapter in Title 10, Chapter 47. The definitions here are pretty intuitive. Apply salt, it means to apply salt to roadways, parking lots, etc. But it's not just for winter maintenance, it's also for summer dust control. It does not mean application of salt to transportation infrastructure construction projects. Remember, AOT already has standards for that, and in some instances, some types of construction, they need to use salt to stabilize the ground. Then a commercial salt applicator is a person who for compensation applies salt or salt alternatives, but it's not a municipal applicator. Page 2, line 1 through 3, a master commercial salt applicator is an individual who can be trained to train other persons within their organization. But again, it's not a municipal or state employee. Salt is every form of chloride that you can think of that's used for purposes of de-icing, anti-icing, or dust control. Salt alternative is everything else that's not containing chloride that's used for de-icing, anti-icing, or dust control. And transportation infrastructure construction project, it's really a project for the construction of roads, parking lots, or sidewalks, or other transportation facilities. Then you get to the creation of the program. ANR, after consultation with AOT, remember AOT already has its standards, and other states, because there are already states that are doing this, New Hampshire, Wisconsin, Adirondack Park is doing it. So after consultation with them, they shall establish the chloride contamination reduction program for voluntary education, training, and certification of commercial salt applicators regarding effective and efficient application of salt and alternatives, provide safe conditions for travel and pedestrians while also reducing the impacts on water quality. As part of the program, this is probably the most mandatory aspect of it. ANR is required to adopt BMPs by rule. To set forth what are the standards that are going to be followed so that a commercial applicator gets that affirmative defense, gets that legal benefit. And so they have to do that by July of 2027. They have to include measures or techniques to increase efficiency of application. So the least amount of salt is used while also maintaining safe conditions. Page 3, line 13 to 15, establish standards for when and how salt and alternatives are applied in order to prevent them from entering the waters, including cost-effective and less harmful alternatives. Whether and how to implement equipment to calibrate, monitor, or meter the application. Page 4, line 1 through 3, when sand is an appropriate alternative to salt or salt alternatives, particularly in regard when application of sand will be less harmful to water quality. They have to come up with record keeping for the commercial salt applicator. This is actually an important aspect because in order to get the affirmative defense, you actually have to keep records of your application. You have to create and circulate a model form for record keeping, establish requirements for certification, establish a testing requirement for applicators to complete, and establish other requirements deemed necessary by the secretary to achieve the program. Then they offer the training for commercial applicators and implementation of the BMPs. Upon completion, the commercial applicator is designated as certified commercial salt applicator. And that certification is for a 2-year term. Page 5, line 3 through 8, those businesses that have multiple commercial salt applicators.
Sorry, every 2:30 we get the crash.
Those commercial salt applicators may get a certified master to train the multiple employees of the company. And then those multiple employees or the company itself receives the affirmative defense. There has to be an annual summary from a certified commercial salt applicator of winter salt usage. ANR has to establish methods to estimate and track the amount of salt applied. Secretary may revoke a certification for failure to comply. The program has to include requirements for certification of the master. They exclude transportation infrastructure construction projects. Page 6. They can elect to implement the program with state agency staff or through a third-party vendor or some combination. Then you get to the affirmative defense. So what is an affirmative defense? So last year in the House version, you just had immunity from liability. And that means that a person really can't even bring an action. If they're harmed, attorney's effectively going to say, well, they're immune from liability. I'm not going to represent you in this action. An affirmative defense allows the harmed person to bring an action, but at that pleading stage or an early stage of the litigation, the person, the respondent, the defendant, asserts, I have an affirmative defense because I can prove all of these facts. And then it becomes a question of, are those facts proven? So you're in litigation. It's not that you're excluded, not that the harmed person doesn't even get to have an opportunity in court. They get to have their opportunity in court, but the defendant can still prove all those things and be judged not to be liable. And so that was important to certain advocates last year. I don't remember their exact name now, the Justice Association. But they really wanted the harmed party to have access to the court and not just be excluded from a remedy. And so that's why you have page 6, the certified commercial salt applicator or the owner, occupant, or lessee of real property maintained by the certified commercial salt applicator has an affirmative defense against a claim for damages resulting from a hazard caused by snow or ice. So one of the key cases where this was tried in another state. The person alleged it was from snow and ice, but then surveillance camera showed the person tripping over like a bush. And so not caused by snow or ice, right? And so, and then the claim damages, any failure or delay in removing or mitigating the hazard as a result of the certified commercial applicator's implementation of the BMPs. And then it does not apply when the commercial applicator is grossly negligent or reckless. And I can tell you what those two things mean if you want to know.
Sure.
So gross negligence is negligence, the failure to perform a duty. That is the failure to exercise even a slight degree of care owed to another. So stated differently, one who fails to exercise even a slight degree of care or acts indifferently to the duty owed to another may be grossly negligent. It does not require that the defendant be aware of the presence of the risk. Now, recklessness is unlike gross negligence. It requires the defendant to know that there's a high risk of physical harm to another, but deliberately proceeds to act or fails to act in conscious disregard of the risk. So one is you don't need knowledge or intent. One is you need knowledge or intent that you are going to cause the harm.
Remind us how it applies here.
Pardon?
Remind us how that applies here.
So if the plaintiff, the person that's harmed or alleges harm, can show gross negligence or recklessness, that affirmative defense doesn't apply because you don't award people with protection from liability when they intend, they know that they're going to cause harm, or they act so without care to the duty that they have that they cause the harm. And then I'm moving on page 6, line 16 to 18. There, if you can somehow show liability of the commercial salt applicator through some other tort action, or the commercial salt applicator can prove their innocence from liability through another defense, both parties are welcome to show that. So this doesn't exclude them from bringing multiple types of claims or multiple types of defenses. But in order to assert the affirmative defense that commercial salt applicator or the owner of the property treated by commercial salt applicator, you're now on page 7, has to keep a record describing their application practices. There has to be some factual demonstration that they met the BMPs, that they were actually implementing the BMPs. Now, in talking to some of the larger commercial applicators, those with significant service areas and equipment, they have GPS and other similar type of equipment that measures all that. And it's probably going to be fairly easy for them to do that. Again, the case in New Hampshire, the company that was sued, they had all of that. And they basically said, hey, we were doing the BMPs. Now, a smaller applicator either doesn't need to be part of this program, but remember, it's voluntary, it's not mandatory, it's offered. Or A&R comes up, A&R is required to come up with a model form that they can use for their recording of application. So trying not to exclude the small applicator, the 1-2 truck company, without requiring them to invest in significant equipment or technology. Page 7, line 7. So remember, this is a water quality program, and it's intended to reduce water quality impacts. But when you are applying salt or de-icing alternatives, you effectively, in some instances, are discharging. And so this gives you a presumption that you are not discharging and you are not violating stormwater management controls if you are implementing the best management practices. Again, which you have to show with your records showing you are implementing the best management practices. It doesn't apply if the requirements are part of a total maximum daily load. You can't effectively exempt yourself or exempt persons from this TMDL for chloride, or to a municipal separate storm sewer system permit. So a municipality that is subject to an MS4 doesn't get this presumption because it's required. MS4 is largely like how you street sweep, how you clean your catch basins, how you apply salt. So it's almost ironic that all of these TMDLs are in MS4. So it's probably not necessarily because of the municipal applicators, because they're aware. It's probably because of the private applicators that aren't subject to requirements.
What are 1263 and 64?
1263 is a requirement to get a permit for a discharge of waste to state waters. 1264 is a requirement to get a permit for stormwater runoff to state waters.
But a private applicator, are they required to get the 1263?
Not right now, no, but theoretically they could.
And still would if it was subject to a TMDL.
To a
What are
TMDL.
they really, I'm not following what they're really gonna get this rebuttable presumption for then.
So they will get it for, say, there's salt applied, chloride applied to a parking lot. There's stormwater runs off into a water. There's impairment of that water. The commercial applicator, the owner says, we were following BMPs. We're not subject to a requirement to mitigate that because we were doing what we were required to do.
But then if that's if the stream is not under a TMDL.
If you're under a TMDL, remember TMDL is mandatory. So there are things in that that need to be done in order to come into EPA compliance so that there's a margin of safety that the water quality standard is easily attainable. You can't really exempt them in that situation.
Guess I'm just curious, like, so otherwise chloride is a contaminant that they would have otherwise been subject to regulation of?
Possibly, it's not
Not having-
right now required, but it is something that if you keep moving in a direction where chloride is impairing your waters, the state's gonna have to respond to that in some measure. And that may include mandates on chloride application. This is not that. This is
Anticipating,
trying to anticipate that. This is trying to put this program into place to drive down chloride levels. So you are not in that situation where you have to take regulatory action for chloride runoff or chloride discharges. But this is also like, hey, remember, it's certain parts of the state, this is really a problem. Certain other parts of the state, it's getting to be a problem. And this parts of the state where it is a problem and you're moving towards regulatory needs, you can give them some surety until that TMDL kicks in. And I don't know what the TMDL is going to look like because it may be you have to tell a commercial applicator in order to operate, they have to be licensed and they have to have certain types of equipment and they have to go through certain types of training. I mean, that's not what this does, but that's ultimately kind of like, if this doesn't fix it, you're gonna have to move to something. And maybe it's you don't use salt. You know, maybe you go back to sand, maybe you find some of the salt alternatives that don't have chloride. but, you know, that's possible. I don't know if you have the supply chain for that, but, you know,
Are you aware of other jurisdictions that have entirely moved away from chloride?
I'm not aware of entirely. I know that there are some that have been trying different things like beet juice and going back to sand or salt sand mixtures or salt alternative mixture, sand salt alternative mixtures. You know, until the 70s, you didn't use salt. You used dirt, sand.
Yep. I get rid of salt while you're going through this.
Um,
Yeah.
and I can connect you with some resources, whether it's the New Hampshire Go Green Snow Pro program, or I worked with a guy in DC who's like salt guru. Um,
Like an advocate for salt or someone who's interested in reducing.
he's head of RFK's old organization, Waterkeeper.
Riverkeeper. Well, we are interested in learning more about salt reduction overall. But
I'll just say that Colchester run out of salt now.
yes, I think a number of towns have run out of
Yeah, so
salt.
it'll be interesting to see what everybody's saying.
Your budget should probably go down, but I don't know. Representative Pritchard, did you have your hand?
Yeah, yeah. I'm just wondering why, I mean, you've given some specific areas, Michael. I'm just wondering why we wouldn't try to focus on an area, implement this program, see if it actually works. Because what this bill is doing is it's implementing it statewide. Am I correct? It's just,
So remember, it's not a mandate for,
I understand.
but I mean, part of the discussion was last year was, what are you gonna do about Sunnyside Brook, which is in Colchester, right by, I think it's like between St. Michael's and Costco. And do you go to a mandate? You go to just a mandate in that area. But is it big enough for mandate? Aren't commercial applicators operating outside that area? Probably are, while also inside. And you go to something that's voluntary and implementable with a legal benefit for both the applicator, and you'll probably get more diffuse buy-in. So you will get a bigger benefit. When New Hampshire started their first year, they had three people go through the training. And this past year, I think it was 1,600. And so it ultimately becomes a benefit to both the applicator and the project.
Just had two more. It's okay.
Yeah, we're not even through the bill yet, but sure, go ahead.
So, and maybe this isn't a question that you can answer, but I'm just curious as to, once this is implemented, there must be an expectation of when we actually see a change. I think.
You know, that's a great question. It's a question that's asked to people that do these programs. And the answer isn't maybe as satisfying as you would like, because the amount of salt used and the amount of runoff depends on the winter that you have. Like this winter, you're having what somebody's called an actual Vermont winter. And so there's towns that are using more salt or running out of salt. When this all falls off, there'll probably be more chloride. So you will see a spike, just like you see with summers with heavy precipitation, the phosphorus spikes. But over time, when you look at some of these graphs, it's like hopefully over time, it will decrease. I can't give you an exact answer because it depends on the rain and you can't count the rain.
Okay, and the last one, I guess was, part of this process, I would think would be verification. So I'm just wondering, and I don't see it, Bill, what, I assume it would be A&R, but who follows through on this and verifies it? And how many additional FTEs might that take?
So,
Because we know they can't do any more work. So obviously, they're gonna verify this, it's gonna involve, would assume, more folks to be hired to oversee it.
so right now, there's no money in the bill because
I realize.
there's a contingency clause. But last year, JFO did an estimated fiscal note and they confirmed those. So A&R would need 350,000 for program implementation, including a one-time $200,000 for contracted services, and then 150,000 for one permanent classified position. And then AOT would look for about $200,000 to do their component, which we haven't gotten to yet, and one permanent classified position. So overall, two permanent classified positions, which after implementation would be about $300,000 total. 50 A&R, 150 AOT.
Thank you.
And there is a provision in the bill as well that says A&R can choose to implement it through contracting instead of through staff. So they can achieve it for a more cost-effective way through contracting. And so there are contractors out there that do it and they do it remotely. Like there's I can't remember if it's the trainers in Minnesota or Wisconsin, but they do it for those states up there,
The training,
the training.
yeah.
We had them in last year. Yeah, I think we had them in last year.
Online.
Mhm.
Yeah, we did.
And enforcement is enforcement. A&R has enforcement staff. They've got cops, for lack of a better term. And so those people are still there. They have enforcement attorneys that are still there. That's not changing. This is just part of it.
Yeah, but it's quite enforcement and verification is
Right.
two separate things.
Most enforcement is complaint driven at A&R, and so it's kind of like there's a complaint, you go out and verify. If there's a problem, you bring enforcement.
But I'm talking about verifying progress on reaching our goals of reducing
Sure.
salt reduction.
Well, that's every 3 years. You got to go out and measure the waters to determine if they're meeting water quality standards, and if they're not, they measure every 2 to 3 years. And they literally monitor all of them.
And the masters will have a certification, like a card, a thing.
Well, that has to be determined because the requirements for the master is something that A&R needs to do in their.
Representative Tony Bear.
With respect to the testing, is there evidence out of New Hampshire? You said there was 3 originally and then there's 1,600 participating in this. Does New Hampshire have verifiable evidence that this program is working?
They have evidence that there's less road salt usage. And they have some evidence of declining chloride levels, but it's not as demonstrable as you probably would like it to be.
brings up my other thing. It seems like this is a heads I win, tails you lose. Where, yeah, there's a little bit of evidence, so we're gonna mandate it now. So
It's
this
not a
goes.
mandate.
Yeah, that's why I said there's a little bit, it looks like it's working, but we want to make it work better, so everybody has to. So all of a sudden it is a mandate.
Yeah, we're not in debate with legislative council.
I'm
Let's,
just saying that
let's
I'm
let
not trying
get
to
through the
debate them.
bill.
I'm just trying to say that's what, this is just that first step. So it's Bill.
We could just keep walking through.
I mean, I have a response to that, but it's a little glib, but so. But. So moving on to page 8, you're in education and outreach. A&R through staff shall conduct education and outreach to let commercial applicators know of the training program, know of the affirmative defense, but also to let members of the public who use salt or salt alternative know of the potential harm to water quality, pets and wildlife from excessive application. And then you come to page 8, line 14. This is the A&R report on management of salt and sand storage. You can see what they are reporting on page 9. It's an inventory of the facilities in the state used for storage, an estimate of the number that are currently covered, an estimate that are not covered and are within 100 yards of surface water or drinking water source. That's another thing, Salt, getting into your wells and your public water systems. I forgot to mention that earlier. Page 9, line 6, an estimate of the number of facilities that are not covered and are more than 100 yards from surface water or drinking source. And then an estimate of the total cost to cover or move, including an estimate of the time necessary to cover or move all facilities requiring cover and movement, and an estimated annual amount of funding that would be needed. Page 9, line 13, this is the program for municipal salt applicators. Municipal transportation, public works employees are trained annually through the Vermont Local Roads curriculum that AOT implements. This would require A&R in collaboration with AOT to identify and make changes to the Vermont Local Roads curriculum needed to support municipal salt applicators, including training for the best management practices. And so then on page 10, you see, notwithstanding the provisions that say municipal employees may be sued under 24 VSA 901A, a municipal employee shall have an affirmative defense against a claim for damages resulting from hazard. And then it's all the same criteria that the commercial applicator had. It can't be, it's because you were, the claimed hazard was snow or ice, but you were applying them according to the DMPs. And any failure to delay in removing the hazard was because of the BMPs. You don't get it if you're grossly negligent or reckless. And it's not an exclusive defense or action. But the municipality on page 11, line 1 through 8 needs to keep a record just like the commercial salt applicator. Now, remember I said that the state can do this through the state employees or through a contractor. But what will ultimately, hopefully, if you have 1,000 people participating or 500 participating, there will be a fee, and that fee will help support this program. But what that fee should be, the General Assembly is asking A&R to recommend it to you, either by the state or a third-party vendor. And so that'll come back to you January 15th, 2027. That's before the program is up and running. And so you'll get to determine on page 12 any fee that you're going to charge for applicators in this program. Section 6 is the contingent funding. As I think you probably know, both appropriations committees are taking funding for new programs out until it comes down to the end and you determine what you want to include, what you don't want to include. The act takes effect on passing.
Okay. Other questions for Michael on this bill? The Senate vote was it 29-1 on the?
29-1. Yeah. There were a lot of questions about demonstrating the need, show me graphs. How many people in New Hampshire did it? What's the demonstrable evidence in New Hampshire? Graphs were, and documentation was handed out on the floor. That answered most of the question.
Do they have a fiscal note?
Yeah, here it is.
Okay.
It's-
On your number.
Yeah, S-218. You can probably find it on the Senate Committee's website. Or actually, it should be under, because it passed body, it should be under just the bill page.
Right. No further questions on this. Do you, Michael, if you, I know I kind of asked at the last minute on these two walkthroughs. If you don't want to do the next one, I understand. If you want to do it, that's great.
I just read it for the first time in over a year, about 5 minutes before I came in. So I would like to refresh myself more than that.
Okay, that's great. Fine. Thanks.
I was in House of Probes on PCBs in schools, and before that I was in a secret meeting. Before that I was in
Thanks. All right, members, is there further discussion before we adjourn the afternoon? Not seeing any.